We are following breaking news. The Supreme Court has ruled in a 6-3 decision that a president has absolute immunity against prosecution for official acts, but they are not immune from prosecution for unofficial acts. Donald Trump has argued that he is immune from prosecution for his actions on January 6th because he was in office at the time. He's facing federal charges out of Washington, D.C. The special counsel's argument was that no one is above the law, not even the president. The decision is expected to have implications for some of Trump's other cases as well. It will also set a precedent for other presidents in the future. Let's bring in CBS News chief legal correspondent Jan Crawford, who is with us from Washington. So, Jan, obviously, we've been talking for a good part of the morning about what this means, but what are the central questions that will have to be decided that are in sort of your immediate viewpoint?
Well, I mean, I think this goes now, of course, back to Judge Tanya Chutkan, who's going to have her work cut out for her. I mean, she's got a lot of work to do. She's going to get some papers from special counsel Jack Smith about what is considered an unofficial act that the special counsel could go forward with on a trial against President Trump. This is no doubt, this ruling, I think, a win for President Trump, but it's not a complete slam dunk victory. It does not foreclose the door to prosecution by any means. It rejects his most sweeping arguments about immunity. He had argued that he was absolutely immune from prosecution, among other reasons, because he was not convicted by the Senate after impeachment. The court says flatly in this opinion by John Roberts, the Chief Justice, that finds no support in the text of the Constitution. They completely say they are not going to embrace that sweeping argument by Trump. But as you said, they're rejecting the government's argument as well. So they've taken this middle ground, which is what we thought they would do after the argument. I do think it is surprising, as we've talked about, they've given the lower court judge more of a roadmap on the kind of things that may be considered unofficial. And so, for example, conversations with the vice president, with members of the Justice Department, those are kind of core kind of duties of the president to communicate with people in his administration. That would be considered official unless the government can show that there are other purposes to it. For example, did Trump have any business talking to the vice president about certification? That's not something that is really delegated to the president to be concerned about. So that's going to be, I think, part of how they try to parse that. It's going to take some time. I think it's going to make it difficult for a trial to take place before November, but I don't think that we can say it's impossible. I think that there is a possibility that Jack Smith could come back and say, I'm going to streamline this indictment again, as we've been discussing. Let's go forward now. She will then make determinations on which of those specific charges and allegations are unofficial that can go forward with the guidance that the Supreme Court has handed down today. And then Trump will be able to try to appeal that back up. The D.C. Circuit, I believe, will quickly say no. And then the court, when it gets to the court, I think if we understand the Supreme Court and what we see the Supreme Court, what John Roberts wants to do is have the Supreme Court out of the election. And I think if this does, what he's given them is a clear roadmap as the majority author of this opinion. And so whatever comes back to the court, I think as long as it is within this roadmap, they won't take this back up. So, yes, this whatever happens next on official versus unofficial could still be appealed, but that is different than what they've done today. That could go very quickly up and then back down.
So you mentioned communications with the vice president or the Department of Justice. Does Chief Roberts' decision lay out in this so-called roadmap whether communications with secretaries of states or state legislatures would be official or unofficial?
Those are things that I think Jack Smith still will try to argue and be able to go forward with. And that came up during the oral argument in a series of exchanges with Justice Barrett, who's a conservative, followed up by Justice Kagan, who's a liberal, where they really got Trump's lawyer to concede that there were areas of conduct that he's alleged to have done, submitting fraudulent statements to courts, filing in lawsuits, working to submit fraudulent slates of electors. There are a number of things that Trump's lawyer conceded in oral arguments are unofficial conduct. So I think Smith will obviously focus on those, and those are not insignificant.
Okay, Jan Crawford, thank you so much. Let's go ahead now to CBS News congressional correspondent Scott Macfarlane. So, Scott, what does this mean for the trial of the former president?
They are sending this matter back with all kinds of bear traps to the district court judge Tanya Chutkan here in Washington, D.C., who does not exactly have an open calendar from now in perpetuity. And they're going to ask her to hear arguments on any number of issues, and all of that raises the likelihood this trial is going to get slowed down prohibitively over a matter of months, not days or weeks. You'll recall Judge Chutkan set this thing for trial on March 4th, 2024, saying when she was first presented this idea of presidential immunity that it was bonkers and that you don't get a get out of jail free card just because you're a former president. But the matters will now come back to her to adjudicate. And there are a few things to note here. She kept a particularly uniquely crisp calendar when she was first dealing with this case in August 2023. She moved fluidly through all the defense challenges. She kept tight deadlines, and she ensured that the parties kept to tight deadlines. She moved swiftly. It's unclear how swiftly she can move, though, through what's about to come to her, these thorny issues that come out of a 100-plus page Supreme Court opinion. Judge Chutkan also has other matters. She has other cases to hear. She has an election week trial on a January 6th riot case. In fact, she has several of those cases coming up for status conferences or sentencings between now and November. Finding time on her calendar is going to be as much art as it is science. This is really going to slow down, I would say, well into 2025.
Scott, do we know yet what this is going to mean for the other cases that Trump is facing? For example, the classified documents case out of Florida. Oh, and by the way, speaking about that case, Justice Thomas wrote in his concurring opinion whether, kind of bringing into question the funding of Jack Smith, which is a question that Judge Aileen Cannon's very courtroom is trying to decide.
It's always worth emphasizing what's alleged in the Florida case is the acts of a former president, not a sitting president at the time. That doesn't mean there isn't a thread the Trump legal team can try to pull on to slow down what is already a painfully sluggish case before Judge Aileen Cannon, who has spent enormous amounts of bandwidth on some of the lesser challenges in that case. So there's a possibility the Trump legal team can try to buy time in that Florida case. But those are alleged acts of a former president, not a sitting president at the time. As for the cases in Washington, D.C., the contrast is just striking as we sit here today. Trump's White House aide, Steve Bannon, with a different case with a nexus to January 6th, is reporting to prison today. He did not enjoy the immunity that former President Trump may be enjoying. There are 1,400 U.S. Capitol riot defendants who have been formally charged, not enjoying the type of immunity Donald Trump might be enjoying today. Some of them are in prison today. Some of them are going to face the prospect of prison in the coming months. Some have already served years. It's quite noteworthy, just the contrast between what Donald Trump is enjoying after this Supreme Court ruling and all those others who've been charged with crimes connected to January 6th have experienced.
Scott Macfarlane, thank you. Let's go ahead and bring in now CBS News legal contributor and Loyola Law professor Jessica Levinson for more on this. Jessica, I just want to pull up, if you'll bear with me, how Justice Sotomayor began her dissent. She said, again, bear with me. Let me find it. All right, I'm going to pull up a different part of the dissent. Oh, there we go. Today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. Today's decision to grant former presidents criminal immunity, well, it looks like it was doubled up. But how would you characterize her dissent?
Well, I mean, obviously, she is very upset about this decision, and we could see this telegraphed throughout the oral arguments where I think the lens she was coming from is no person is above the law. So how can we possibly say that when it comes to somebody who's head of the executive branch, that they enjoy immunity from criminal prosecution? And I think what she's saying is there's just something different about criminal cases, that the public's interest in saying we can hold a president or former president accountable for their actions is higher than, for instance, it is in civil suits, where we know that there is absolute immunity from liability based on official acts. So Justice Sotomayor is just viewing this very important problem, I would argue, through a different lens. And what she's much more worried about is, I think, the impact on the public, the impact on prosecutors of saying that there is something different about somebody who is or was the president of the United States. And the majority is just viewing this question again through a different lens, saying presidents are different, and that when it comes to certain things that only presidents can do, for instance, they should enjoy immunity from criminal prosecution, in part because it's not that we're worried about former President Trump necessarily, it's that we're worried that any current or former president would be subject to a variety of criminal cases that could undermine their ability to do their jobs. And so it just, I don't know how to kind of frame this other than really different lenses to view this constitutional question.
During oral arguments, there was a lot of back and forth over whether a president can only be criminally charged if he or she was impeached and convicted first. Did the decision address that?
Yes. So the argument here that the former president put forward, saying I have to first be impeached by the House and convicted by the Senate, is not an argument that the Supreme Court adopted. That's not what the majority was saying here. The majority said something different, which is they did give the former president a win in terms of finding some immunity from criminal prosecution, but it's not based on the idea that first you need to be impeached and then you need to be convicted. It's based on what they view as frankly, a separation of powers concerns and the need to protect not an individual, but the office of the presidency and former presidents. And again, we can have a discussion about where we would each draw the line, but it's a really good question. They did not adopt, and we could see this in oral arguments, they didn't adopt this argument that no criminal prosecutions unless you're first impeached and convicted.
What does this mean for, we discussed with Scott sort of what this means for the former president's other criminal cases that he faces, particularly in Florida. But have you begun to view this decision in the lens of what defendants are facing in Georgia and Arizona for racketeering, for fraud, for conspiracy, forgery?
It's such an important question. So the Georgia case is much more similar to the federal D.C. election interference case. And I think Scott laid out very clearly what's going on in Florida. But for the Georgia case, again, that is kind of the state, in some ways, the state analog to the federal case. And so we're going to have to ask the same question. So is the president charged with things that we would consider to be core functions of the presidency, things that only a president can do? Then there's absolute immunity. Is the president charged with official acts? Then there is at least a presumption of immunity. And then are these private acts or unofficial acts? Then no immunity. And this means Fani Willis moved forward with this case. And we know for a variety of reasons that case stalled out. I think my big takeaway is the Supreme Court provided a roadmap, frankly, one that was more detailed than what I anticipated when it came to the charges in the federal case. And this roadmap will take some time to apply. I don't see any more cases moving forward before the election. And we know that depending on what happens in the election, that might mean that no cases move forward. And we can talk about the difference between why the state case wouldn't move forward versus the federal case. But that's the bottom line for people watching at home is I didn't think yesterday, and I don't think today, that any of the criminal cases will move before the election.
Okay, we'll have to move state versus federal to another day. Jessica Levinson, thank you so much.